Now I am going to dictate a legal passage at the rate of 120 words per minute based on latest Calcutta High Court judgment appellate side. Let's start. Instant appeal has been preferred against the judgment and award dated 13th August 2018 passed by the learned judge Motor Accident Claims Tribunal 3rd Court Nodia Krishnanagar in MAC case number 271 of 2015 para. The brief facts of the case is that the victim of this case, namely one Dev Kumar Saha, on 28/07/2015 at about 3:15 p.m. when he was going toward Chhapra side from Krishnanagar side riding on his motorcycle. At the time, the offending vehicle number WB23/9032 within bracket track, which was going towards Krishnanagar side from Chhapra side in high speed in rash and negligent manner. The driver of the truck lost control over the vehicle and dashed victim along with his motorcycle. As a result, the victim sustained multiple injuries over his body and were shifted to Nodia District Hospital, but the doctor declared him dead para. The widow, children and the mother of the deceased preferred an application under section 166 of MP Act before the learned tribunal for getting compensation on the ground that the accident caused solely due to the rash and negligent driving of the offending vehicle, duly insured under the policy of the insurance company para. The claimant's case was contested by the insurance company by filing written statement para. After hearing the parties and after receiving the evidence, the learned tribunal has awarded a sum of rupees 3,69,500 in favor of the claimants and directed the insurance company to pay the compensation. The insurance company has satisfied the award through the office of the learned tribunal. The claimants have preferred the instant appeal for enhancement of the compensation. Mr. Roy, learned counsel appearing on behalf of the appellant, submits that the award passed by the learned tribunal is erroneous. The calculation of the compensation in this case by the learned tribunal is not justified and not in accordance with the provision of law. He further submits that the income of the deceased as assessed by the learned tribunal is completely erroneous. In this case, the learned tribunal has adopted the income of the deceased nationally rupees 3,000 per month, while the deceased had a business of Messrs. Dipta Bostro Biponi, wherefrom he used to earn a huge amount of money and had filed the income tax return to the concerned department year after year. He further argued that the income tax returns were submitted by the claimants before the learned tribunal and these returns were sufficiently proved through the person's income tax, but the learned tribunal has erroneously not considered the income of the deceased on flimsy ground. He submits that the claimants had filed the income tax return of the deceased for the assessment year 2012 to 13, 2013 to 14 and 2014 to 15. Amongst them, the income from assessment year 2013 to 14 is highest of rupees 1,97,490. Mr. Roy further submits for the purpose of assessment compensation under section 166 of the MB Act, the highest annual income of the deceased bearing income tax return has to be considered as an income of the deceased. In support of his contention, he stated decisions of the Honorable Apex Court passed in this case is para. Mr. Roy further submits that the learned tribunal has also committed error in awarding the compensation wherein the deduction towards the personal expenses of the deceased was made 1/3. It should be 1/4. He further argued that the learned tribunal has failed to award the future prospect and general damages in this case according to the observation of the Honorable Apex Court. in National Insurance Company versus Pranay Shetty, Mr. Chakraborty, learned counsel appearing on behalf of the insurance company refuted the contentions of Mr. Roy and submits that the learned tribunal has observed the reason. Stop. Thank you.